Hi friends, in this video we are going to deal with the case summary of the latest Supreme Court Constitution Bench judgment pronounced now in the area of criminal law, especially matters involving that direct evidence of demand or acceptance of bribe is not necessary to convict a public servant under the Prevention of Corruption Act. To know more about it, please watch this video fully. If it is helpful to you, please like, share and comment, and never forget to subscribe to it, and further click on the bell icon next to the subscribe button. In the important judgment titled NEERAJ DUTTA versus State Government of N.C.T of Delhi, pronounced on 15th December 2022, the issue as to whether the demand for illegal gratification could be established by other evidence in absence of complainant, relating in direct evidence of demand owing to the non-availability of the complainant or owing to his death or other reason, was referred to the Constitution Bench of the Supreme Court. The Supreme Court has held that proof of demand and acceptance of illegal gratification by a public servant as a fact in issue by the prosecution is a sine qua non in order to establish the guilt of the public servant under Section 7 and 13(1)(d) 1 and 2 of the Act. In order to bring home the guilt of the accused, the prosecution has to first prove the demand of illegal gratification and the subsequent acceptance as a matter of fact. This fact in issue can be proved either by direct evidence, which can be in the nature of oral evidence, or documentary evidence. Further, the proof of demand and acceptance of illegal gratification can also be proved by circumstantial evidence in the absence of direct, oral, and documentary evidence. In order to prove the demand and acceptance of illegal gratification by the public servant, the following aspects have to be followed, and they are: the first one is, if there is an offer to pay by the bribe giver without there being any demand from the public servant, and the latter simply accepts the offer and receives the illegal gratification, it is a case of acceptance as per Section 7. In such a case, there need not be a prior demand by the public servant. The second one is, on the other hand, if the public servant makes a demand and the bribe giver accepts the demand and tenders the demanded gratification, which in return is received by the public servant, it is a case of obtainment. In the case of obtainment, the prior demand for illegal gratification emanates from the public servant. This is an offence under Section 13(1)(d) 1 and 2. The third one is, in both the cases, the offer by the bribe giver and the demand by the public servant, respectively, have to be proved by the prosecution. In other words, mere acceptance or receipt of an illegal gratification without anything more would not make it an offence under Section 7 or Section 13(1)(d), the subclasses 1 and 2 respectively. Therefore, under Section 7, in order to bring home the offence, there must be an offer which emanates from the bribe giver, which is accepted by the public servant, which would make it an offence. Similarly, a prior demand by the public servant, when accepted by the bribe giver, and in turn there is a payment made which is received by the public servant, would be an offence of obtainment under Section 13(1)(d) and 1 and 2 of the subclasses. The presumption of fact with regard to the demand and acceptance or obtainment of illegal gratification may be made by the court of law by way of inference only when the foundational facts have been proved by relevant oral and documentary evidence and not in the absence thereof. On the basis of the material on record, the court has the discretion to raise a presumption of fact while considering whether the fact of demand has been proved by the prosecution or not. Of course, the presumption of fact is subject to rebuttal by the accused, and in the absence of rebuttal, the presumption stands. In the event the complainant turns hostile or died or is unavailable to let in his evidence during trial, demand of illegal gratification can be proved by letting in the evidence of any other witness who can again let in evidence either orally or by documentary evidence, or the prosecution can prove the case by circumstantial evidence. The trial does not abate, nor does it result in an order of acquittal of the accused. Insofar as Section 7 is concerned, on the proof of act in issue, Section 20 mandates the court to raise a presumption that the legal gratification was for the purpose of motive or reward as mentioned in the said section. The said presumption has to be raised by the court as a legal presumption or a presumption in law. Of course, the said presumption is also subject to rebuttal. Section 20 does not apply to Section 13, 1D, the subclasses 1 and 2. Accordingly, the Supreme Court has held that in absence of direct or primary or oral or documentary evidence, it is permissible to draw an inferential deduction of culpability or guilt of a public servant under Section 7 and Section 13(1)(d) read with Section 13(2) based on other evidence adduced by the prosecution.